and I want to have more of an in-depth conversation. And we have two really great guest speakers that are here today, Miss Jennifer Orns and Mr. Jody Staples. I'm going to bring them both in so that we're going to have this conversation. And for those of you that have not had an opportunity to work with either of these individuals, they pour so much into their business. They pour so much into each market center. Jennifer and I had an opportunity to work closely together when she was in the downtown office. She and Lonnie are working to build over at the beach office. And then Mr. Jody Staples is a huge help with the Keller Williams Seminole office. Hi, Jennifer. So just setting this up, Jennifer, what is the focus today with Addenda? Why are you so passionate about teaching Addenda and contract classes, and what does this mean for you and your business?
This is a step into why we do our business. This is professionalism. It's a step up to why we are professionals. You know, this is, I mean, we can't do our business professionally and we can't get paid unless we really, really know the contract and we also know the addenda. There's, you know, did you know that there's 3 ways to actually cancel a contract in the condo writer? If you don't know that, then you won't get paid. You could drive people around for hours and then you can show them property or for days, and then you could go ahead, go under contract and on a condo, and then you could go ahead and get canceled by the other agent because you didn't know your job.
Absolutely. And now, Jody, you know, I joke in this part, Jennifer, you know, we get paid the money that we get paid because of the knowledge around the contracts. I don't think you're going to get sued for showing ugly carpet. You absolutely can get sued, to Jennifer's point, by not taking the time to actually learn the contract. So Jody, why are you here? Why are you passionate about sharing this morning with our agents?
You know, for a couple of reasons. One, I'm a contract nerd and I just love this stuff, which is embarrassing, but it is what it is. So, you know, part of it is, I want to touch on, you know, what Jen said, it is the professionalism, because that's what we're bringing to the table. There are a lot of people think that they can do our jobs. They can look through Zillow and all they need is us to open the door, and how we show our value is our knowledge and our expertise. And that's part of this. Another part of it is, you know, the contract, and these addenda are incorporated by reference to the contract. So this is part of the contract. The contract is a tool, and either we're going to use it effectively to represent our clients, or someone's going to use it on us. And the more knowledge we have, the better we can represent our customers or our clients, and the better we can use these tools.
Absolutely. So with that, let's get right into it. So Jennifer, which I know that you've already kind of alluded a little bit to the condo. So are we focused on the condo writer today?
Yeah, we actually, by the way, hi Jody. I'm so excited to be
Hey, Jen.
So this is the Jen and Jody show, or the Jody and Jen show. I know you said the Red and Reedy show or Reedy and Red show. This is the Jody and Jen show. So we're gonna start this, and I'm so excited to be teaching. We have an attorney in the house. Woo-woo! I'm so super excited about that, because I always absolutely love it when I get to talk to an attorney and I don't have to pay you. Sorry, Jody. But it's such a pleasure to have the opportunity to teach with you. You are so brilliant in everything you do. Plus, you're incredibly funny. So we have a really great day here at 9 a.m. in the morning, and I know that your Xbox is like really close to you. So I know, and we're teaching Addenda, not exciting. So we're going to make sure that we try and make this as fun and exciting as possible for you, so that we don't put you to sleep, because this is, you know, it's a little bit dry. So what we do want to do is we want to preface this for you with a little bit of a statement. You know, when we're teaching this, it's when you receive these addenda. By the way, addenda is plural. Addendum is singular. Just want to say that real quickly so you can use the correct language. If you don't get it right, don't worry about it. But I do want to preface this with what Jody and I were talking about yesterday. Is we go 4,000 miles an hour in this business, and you know, we just put these things in DocuSign and we say, okay, go ahead, Mr. Buyer, sign this, Mr. Seller, sign this, whatever. And we don't like stop and think about the meaning behind what we're asking them to sign. You know, we can stop and say, okay, think about the liability that we're asking our folks to sign. Maybe they don't have to sign it. We just received something from Coldwell Banker recently, and it was addendum that they had. It was a COVID-19 addendum, not the one that Farbar had just put out, the MLS had just put out. It was one that Coldwell Banker, nothing against their brokerage, but it was something that they had put out that they said, okay, we're going to automatically extend the contract right in the beginning, an automatic extension for 30 days. Did we need to do that? Who knows? There was no need to automatically extend right in the beginning during the first offer. During the negotiations, there wasn't an automatic need for an automatic extension. So the COVID-19, which Farbar and the MLS had given us, is a negotiation tool, which Jody will talk about during this class. You know, so I immediately contacted the buyer agent and I said to her, you know, I talked to my seller because it's the seller that we have to talk to. I don't have the choice in these signatures at all. I always have to go to our client. So I spoke to my seller and I said, you know, Karen, we really don't need to sign this, and I'll explain why. And I did explain to her the risks of signing this, and she understood. And she said, no, Jen, I don't need to sign this. Let's not sign this. And so I went back to the buying agent and I said, my seller chooses not to sign this. So please, when we receive these addenda, go through them and stop and think, you know, what's the liability? Jody, would you like to add anything to this?
You know, actually, you said it perfectly. I mean, don't just shove it in front of them, because if we end up in court, you know, what's going to happen is the customer or the client, the buyer or the seller, is going to say, well, my agent gave it to me and told me to sign it. And, you know, we're considered the professionals, so we need to be professional. We need to make sure that they read through it and that they have a good understanding. We're not attorneys. So if they have a real issue with something, if they really need a legal opinion or a legal explanation, then we need to be the source of the information. You know, direct them to talk to their attorney. And there's some things that are a little confusing, but you know, we need to be really careful about giving legal advice that may be construed as us practicing law. So they need to read it, they need to understand it, and if they have real issues, they need to talk to their attorney.
Right, and you know, call one of us if you have any other questions. You know, they can call Jody at Seminole, they can call me, they can call Murray, you know, they can call Rachel, whatever. But you know, call them to make sure. You know, are you having your client being held harmless? You know, on one of these addenda. All right, thank you. I think we've said that enough. Okay, the other thing I wanted to say, by the way, Jody, you introduce yourself. I don't know, most people might not know who you really are. So please, besides being an attorney, you're-
I'm Jody, Gemini, like long walks on the beach. No, just kidding.
Favorite color.
Yeah, right. I'm an attorney. I started out in the Seminole or in the St. Pete office, and then I went over to help launch the Seminole office. I've been a licensed real estate agent and also a licensed attorney for over 20 years. I prefer to practice, you know, real estate now. I have a 12-year-old daughter, and you know, this gives me the flexibility to have the time to be the kind of dad I want to be, and yeah, I've been loving it. So that's I guess the short version.
And he's an amazing agent. You're minimizing it. You do a great business. And you're really, you know, a mega agent too. So, and an incredible dad. You're always posting about your so.
All right, I have share screens if you need it.
Pardon?
I have the share screen up, so if you need it.
Oh, okay, excellent. Thank you so much. All right, let's get into the meat of it, shall we?
Sure.
You know, I wanted to also start out by just talking also about you know, everything, all of this that we'll be referring to is on the section 19 of the contract, and it refers to both of the contracts. So section 19 all the way down at the bottom of the as is or the standard contract. So this is section 19. These are all of the addenda that we'll be using and referring to. I don't know if you have the shared screen on the contract.
I'm going to 19.
19. Thank you so much for doing that. I asked you, there it is. Thank you so much. So these are all of the sections that you're going to have to make sure that you check. Please take care that you check all applicable addenda and then include them in the contract. So if you do check these, make sure that they go along with them and that you check them. You know, the best practices is also to make sure that at the listing agreement, you go ahead and get these signed and then attach them to the MLS. So that best practice is so that you can go ahead and when you do have a buyer who wants to make an offer, that they can go ahead and download these attachments. So that's best practices so that you don't have to, you know, the buyer's agent isn't going ahead and saying, okay, can you please send me the seller's disclosure? Can you please send me the lead-based paint? Can you please send me AA licensee property interest disclosure? You know, so that these all are attached to the MLS if they need to be, so that they're immediately, don't have any issues with having to send these. And, you know, then you're having to play catch up at the end, or condo writer. Does that make sense? So, all right, so these can be attached to the MLS so that it's an automatic, so you don't have any problems. You know, please take care that you check all the applicable addenda and then include them with the contract. If later decide not to include a particular addendum, it should be struck through at paragraph 19 and all parties should initial and make the change. Also, please remember to use the form of the addenda that matches your contract. For the standard and the as is, you should always use the CR5 version of the addenda. While FARBAR, FRAC Attorney Hotline, and others have opinion that mismatched addenda may not render your contract enforceable, using the incorrect form of the addenda certainly creates ambiguity, which could lead to unenforceable issues. Also, the addenda and the contracts are designed to work together. So if you're using a crisp addendum and a FARBAR contract, that could lead to a unenforceable contract. Does that make sense? So you want to make sure that you're using a FARBAR addendum with, or a FARBAR addendum or CR5 addendum with the FARBAR contract. Okay? Any questions? I keep on forgetting to look at the chat. I will continue to look at the chat.
All right, writer A?
Writer A. Thank you. Can you keep me on track and look at the chat to see if we have anything going on?
I will also be able to do that. I'll bring questions up if need be.
Great, that'd be awesome. Thank you.
Absolutely.
We are both, we both agreed before we spoke, and we both said that this is not something that we're great at. So writer A, condominium writer. As I said before we even started, that there's two ways to terminate, one way to void a contract. I've had this happen to me. And it's not the best feeling, but it does happen, even though you know that this can happen. So the situation was where we were under contract. I had the listing, and it was a very small condo complex. And in the very first paragraph, where it says that because you actually have only 5 days in this very first paragraph, after you go effective, you have 5 days to make application. And in that very first paragraph, it also says that you have 5 days prior to closing to obtain approval. So 5 days to make application after the effective days, but you only have 5 days before closing to have the association to get the approval. So I'm a listing agent, and it was a small little 5-unit association complex, and it was run by the actual members of the complex. It wasn't run by a management company. And this 90-year-old woman was the president of the association, and she took forever to have the buyer approved. And the buyer actually voided the contract because she never actually approved the buyer. She was, I think, going to approve him the day before closing. And so they went ahead and voided the contract. And it was literally an email, I'm voiding the contract. And he got his escrow back. And that was legal as per paragraph 1. And so this happened to me. So you have to know this, that the condo writer, this can happen. So you have to watch your dates. This is the most important thing about the condo writer, is in the critical dates, you have to make sure that you're continually tracking your dates. So when you're doing your critical dates email, which we do on every single contract, effective contract, we send out a critical dates email. Best practices, again, always send out a critical dates email. Send out the best practices and send out your critical dates. You have to make sure that you watch your dates on it.
Did we lose Jen?
I think she's frozen for a moment.
All of your documentation
There we go.
at the time of listing, all of your conducts, try and get everything at the time of the list appointment. You don't have any issues with that at all. Because if you can obtain all of your condo documents, then you can know what the process is for the application, and talk to the seller also. What is the process for the application? Is there an application face-to-face? Like does the buyer have to meet face-to-face with the board members? Then if that's your bottleneck, you can make sure to have that happen as soon as possible, so you don't have this problem where you get a contract voidable. Any questions on that? Michael, are you checking our questions?
Yes, ma'am. None at the moment.
Thank you very much. Okay, next, paragraph 2. Oh, hold on 1 second. I will, here, can you take my phone? Here, look up Alan's number, sorry. Paragraph 2, suppose in paragraph 2, so this is where it gets a little bit tricky. This little tricky only because do the members have the right of first refusal to buy the condo unit? Oftentimes we'll find this out in the declaration of condominiums, and that's why I really want to preface that you get all of the documents at the time of listing appointments, but you shouldn't be the one that's understanding this information. Really, the seller is the one that understands this information. Ask them, do you know if the members have the first right of refusal to purchase the condo unit? And a lot of times this also happens if the unit is in arrears for the association, and also if the unit is in arrears for their mortgage. So is it a short sale, or is it in arrears for they haven't paid their association dues? So this gets into if they're in arrears for the association, and also if they're in a short sale. But it doesn't necessarily have to be those two situations. So this all refer to that. If the members do have the right to first refusal to purchase the unit, or if they don't. And again, all of that is laid out in the condo decks. So in the condo documents, and really that's going to be laid out in that, and either the seller will know that or the management company will know that. Do they have, the members have the first right of refusal to purchase the unit? So that's going to be laid out there. And if they do have first right of refusal, this goes into, the fact that if the members do have the first right of refusal, then actually this contract will terminate, and the buyer will go ahead. If they have gone under contract already, then the contract will terminate if the members do want to purchase the unit, and then the buyer will go ahead and get the escrow back again. So this section is a little bit tricky if you've already gone under contract. So there's the second area where the condo writer does terminate. The last way the contract may terminate is as set out in paragraph 5B. The contract is voidable by the buyer within 3 days after signing the contract. Okay, this is very interesting, Jody. I don't know if you knew this. Did you know this? If you don't give all of the condo documents that are laid out in this section, in the list, and the list is laid out in the condo rider. This list in section 5B. All of these documents that are laid out so beautifully, and it says the receipt by the buyer of current copy of the declaration of condominium, articles of incorporation, bylaws and rules of the association, and a copy of the most recent year-end financial information, and frequently asked questions and answers. So there's your list. Did you highlight that for me?
I can.
Do you see that list? Yep, there it is. And it's so beautifully laid out for you. So if you don't give that list, Jody, did you know this? That the buyer can actually, if they don't receive it by the closing date, they can actually extend the closing date by 3 days.
That's crazy.
Get that on the closing date. This whole entire list, they can extend it by 3 extra days. And then they can cancel the contract. They can actually void the contract if they haven't received this. So could you imagine if an agent goes ahead, the listing agent goes ahead and gives you this list on the closing date, and then the buyer's agent goes ahead and extends 3 extra days for on the closing date, and then voids it, the contract? Could you imagine that happening?
There go your referrals.
Oh my gosh, you would be like so pissed off at your agent, wouldn't you, if you were the seller?
Absolutely.
I've heard of crazy things happening like this. And then the buyer gets their escrow back. So, best practices, what would you suggest?
You just pretty much covered it. I mean, get the documents organized in the very beginning. Put whatever documents you need to put in the MLS, and talk to your seller. Find out, do they have a right of first refusal? Get all the information right from the beginning so you're not surprised somewhere along the transaction or at the closing table.
Okay, well, interesting thing that you just said, put them in the MLS. So I'm going to backtrack on that comment. So I might argue with you, counselor.
But I'm not referring to all the declaration of condominium, all that kind of stuff. I'm talking about the condo rider. The documents they need to be able to complete. I'm glad you brought that up. The documents they need to be able to complete the contract, because with this and the HOA, and this is probably where you're going, we want the sellers to provide the documents, or the HOA to provide the documents, or in the HOA, the buyers to get them from the HOA. Because if we happen to, for example, give a document, it's an old document and it's been amended, and there's some material change that's important to the person that's buying it, and they buy it. This would be on the easiest on an HOA example is people like to park their boats in their driveway. And the HOA may have made a rule you can't do that. The old documents you gave them say that you can, there's nothing against parking a boat on a trailer in the driveway. The person buys the house and they find out they can't do it because you gave them old documents. You've injected yourself into the transaction, and you may be partially liable for this. So we want the sellers to provide the documents. We want the buyers to get the documents. We want to be the source of the information.
Jennifer and Jody, so we've got 2 questions. One is, how do you handle...
Before you start that, hold on, sorry, 1 second, real quick,
Yep.
because I wanted to just add on to what Jody said there. I want to make sure that when you do have those documents delivered to the buyer's agent, because delivery is always part of our job, I want to make sure that you send those by email to the buyer's agent with a notice on that email. Please reply that you have received these documents. Please reply to this email that you have received these documents, because I want to make sure that they make sure that they have received the documents. And then there's a beautiful place in this document on this line on the next page that says receipt of condo documents on section 7 that the buyer's agent can go ahead and sign on the next page. Thank you very much for highlighting. You're such a great, you're doing so well. Thank you so much. It is the Jody and Jen. So I'm going to put your name first on this show, okay? So it is, so right there on line 7, and then there's the date of receipt. If you get all of these documents in advance at the listing appointment, you have this condo writer signed, you check this box, and you have it all done right in advance, then you send them to them immediately upon the offer and the contract. You have this date filled in immediately. And then you say, please reply that you have received all of these documents. You put this date in right there. I mean, it's done. Then you start your 3 days of rescission on receipt of these documents. They cannot void, or they have those 3 days and they can void that contract during the inspection period if they see anything in the documents they want to void. I apologize. I just wanted to make that clear that it is your job to deliver them, and it is the seller's job to pay for them, by the way, at the seller's cost, not the agent's cost. I want to make that clear too, that it is not the agent's cost, it is the seller's cost. Okay, all right, sorry, Michael.
No, please. I know that you're not able to see them in, so always swat them down until you're ready to accept them. Trish has asked, how do you handle it if they say that the frequently asked questions or another document does not exist?
Thank you very much. Great question. You know, that's okay. Oftentimes the frequently asked questions don't exist. It's an odd thing. Honestly, I've had this argument that meeting minutes are kind of like the WWF of the Worldwide Wrestling, no, WWW. What is that? I don't watch it, so I don't know what that is. But that's like the meat of everything in a condo that should be included. I think the meeting minutes are the most important thing. I don't know what frequently asked questions are. You know, whatever they are. But I think that the meeting minutes are the most important thing in the world on a condo. So I go after that like a dog on a bone. I cannot get enough meeting minutes. I don't know what you do, Jody, on best practices.
I'm with you. So, I mean, I try to make sure that, you know, this goes along with several other documents we'll talk about. I always encourage my buyers and sellers disclose, you know, and this goes along with it. Give whatever information you have, whatever information you get, to be able to allow the buyers and sellers to be able to make informed decisions. That goes along with buyers. If you can, you know, even if it doesn't sound important, the frequently asked questions, you know, go after it, like you said, like a dog with a bone. Get what you need to get it to them to make sure we're complying with the law, or that we've made a paper trail as to why we're not.
Agreed.
Wonderful.
You know, I had one, it wasn't my own client, but I ended up having to short sale her unit for her, unfortunately. But she was not given the meeting minutes in the previous, when she purchased the unit. So I ended up having a short sale, but in the meeting minutes, if she was given it, there was an assessment that it was spoken of in the meeting minutes only. And it stated that there was going to be an $11,000 assessment to the unit. And if the previous agent had told her that, she wouldn't have purchased the unit. But when she was able to, she did purchase it. She found that out afterward, and it put her into that $11,000 cost, put her into a short sale situation. So I had to short sale the unit for her. So that's why I will never forget that. And I will always make sure that meeting minutes are part of, sorry, we have big dogs. So, of course, working from home. So that's why meeting minutes are such a huge thing. I get as many meeting minutes as I can for my folks, because that's where everybody's like arguing like wrestlers in, you know, in a ring. You know, they're always talking about what's going on. And actually in section, like I just wanted to point out, and then we'll go back to questions as well. So thank you so much for all the questions, because this is a really important document. And that's where I knew that we would need an hour and a half on this class, because I knew that this was going to be a lot of the questions as well. But if you go to page 2, in section paragraph, sorry, 3C 4 or IV, if you're under contract and you all of a sudden say that you're under contract and there's an assessment that all of a sudden comes up, and they're not just talking about the assessment in the association, which we've had this happen. I've actually had this happen myself. They're not just talking about the assessment, but the assessment has been imposed during the contract. Then this actually speaks to what happens if the assessment has actually been imposed while you are under contract. Then the seller shall pay all amounts due before closing date, and the buyer shall pay all amounts due after closing date. Interesting. So I was looking for this because it happened, and then I also had a question about that. So any special assessments that have been imposed while you are under contract. And then the other thing I do want to say about this as well is if you are in contract and an association dues increases, so say you're under contract and the year changes, oftentimes you want to, as a listing agent, contact the association between, like if you're listed between December and January, best practice is to contact the association to find out if the monthly dues has increased during the year change, because oftentimes it has increased. So you also want to stay up on your listings during the year change and make sure you're calling the association to find out what has your association dues increased, changed to make sure that you're accurate on your condo association dues or your homeowners association dues during your year change. So always make sure you're continuously staying in touch with your sellers and your association. Questions?
Yes, we've got a lot of them. So this is the same topic, but there are two different things. So if you could touch on it. Barb Degan says meeting minutes aren't listed as condo docs. And then Kim Van Herwijnen said that she had an experience with a particular community and was told that meeting minutes are never given. So when addressing meeting minutes, both of you, however you want to take that, just in general, on getting the meeting minutes, delivering the meeting minutes, and if that's included or not included in the actual condo docs.
So meeting minutes are not included in the list. I've actually spoken to folks who have powers greater than me to try and get these added to the official list, because it is definitely a super important thing that I believe should be added to the list. Jody, do you want to add anything to this? I mean, it's not included in this list, but I try and ask for it and do the best job I can for my clients.
That pretty much covers it, Jen. That's exactly it. Because that's what's going on in the condominium. That's what may be coming down the road. And, again, you're disclosing everything that you're providing, or you're facilitating the disclosure of everything that the condominium association is doing.
It's pretty much in tune with seller's disclosures, in my opinion, because if you're the seller, you have to disclose anything that materially affects the value of the property. In the meeting minutes, they're discussing anything that could materially affect the value of the property. And this is a cost value. Next question.
We've got a clarifying question from Debbie Watts that says, so when we receive this filled out from a buyer with a contract, we send it back with paragraph 7 checkmark with all the documents in paragraph 5, correct?
So paragraph 7 is that you are agreeing that you have received the
Jennifer, we lost you. There's a snag there as soon as you started talking about paragraph 7.
Well, I mean, I'll jump in here real quick.
Okay.
So the question was, what did we just
to clarify, okay. Yeah, it was to clarify when receiving this filled out from a buyer with a contract, we send it back with paragraph 7 checkmarked with that all the documents in paragraph 5, correct?
Yes. And so once they've received them all, on the selling side, you actually can fill this in and have the buyer check it because you know the date that they received it. If you've emailed them all, that's what Jen was touching on. If you've emailed them all, then you know the date that they received them, and you can fill this section in, and the buyer can check it. And it does involve all the documents that are listed up here in 5B. Does that answer the question? Hi, Jen.
Yes. Okay, great.
Sorry.
No, wonderful. Jody handled that one for you. And now the next one, Veronica is asking, what happens if the docs are changed after receipt? Are we required to forward changes?
What happens if docs are, sorry?
It says, what happens if the documents are changed after the receipt? Are you required to forward changes?
Oh, definitely. Definitely. If the documents, if there's any change to the documents as far as like if there's an increase in the association dues, correct. Yes, you are required to, definitely. And then notify them, call them and make sure that they've received them. And definitely. We've had that happen where during the contract there's been an increase in the association dues. So we've notified them immediately.
Wonderful. Kimberly or Kim Van Herwanen said, do you need to check off 7 and have buyer and seller initial there?
Correct. If it wasn't immediately done upon the offer and the effective contract, then yes. If it was done during the contract, like when you went under contract and then they were sent afterward, then yes, what we've done is we've sent it, put in the date, and then had all parties initial. Jody, is that how you've done it as well?
Yes.
Okay.
Wonderful. And that's where we're pretty caught up on questions at the moment.
Okay, excellent. Then the next part of the condo writer also goes into the common elements. Make sure that you list any parking spaces and garage spaces. Then it goes into the inspections and repairs. Let me see if there's anything else that really needs to be addressed. Gosh, am I really done with condo writer? Let me make sure. If there's anything else I need to, I wrote down these notes. It goes into sprinkler, retrofit, and also includes handrails, guardrails. I think that's it. Most current version. Yeah, that's it. That's it. Wow, I finished condo writer. That's it. I really think though that tracking your dates on this is just very important to make sure that you understand where your dates are.
So Jennifer, you brought up a good point, both you and Jody, about paragraph 7 and if it happens after receipt. So from a best practices perspective, to your point of not necessarily putting the condo documents in the attachments on the MLS, when are you delivering the documents if you were trying to anticipate so that you didn't have to do revisions to the condo writer?
As soon as I go to the listing appointment, I am talking to the seller about getting these condo documents as right there. If they have them, I can get them at the appointment as I'm getting everything signed. If they don't have them, I'm asking them, we have 24 hours with which to get them back their listing paperwork. And so after I get the paperwork back to them within that 24-hour period, I'm emailing them and saying, by the way, I need your condo documents. And here's the list of everything I need. So in that email, as I'm sending them back their listing documents, within that 24-hour period, I'm going ahead and I'm asking them again for their condo documents. I am hounding them for their condo documents because if I don't get this, the buyer they can void the offer, the contract within 3 days. Why give them that time after inspection?
So when are you delivering the documents to the buyer?
As soon as we get the offer.
Okay.
So why not? Because they can go ahead and review them while they're sending the offer back and forth. And then they can go ahead and go under contract, and they can sign Section 7 and say that they've already received everything while we're effective. And then that date starts, that count starts, and then we're going through inspection, and also that 3 days is counted. So I can track that date and say day 0, day 1, 2, 3, done. They can't contract anymore.
To this point, just to clarify, it's the buyer received the documents, not the buyer had an opportunity to look them over and be comfortable with them. So that's basically an email. I mean, you receive the offer, you get an email, the buyers receive them, because Standard O says notice delivery to the agent or the attorney of the buyer or seller is the same as notice, or delivery to that party. And so once you've delivered it, they've received it. Just have them confirm, as Jen said. They can read it at their leisure, but they haven't. So now you've taken care of Section 7.
This is why we love having an attorney. Thank you very much. Standard O, and you even know to reference the standard. Delivery, and that is part of our job, is delivery. Thank you.
We do have another question. Doreen is asking, should we list a property if members have the right of first refusal?
Excellent question. So find out what their rights are, and then go ahead and ask the seller, what are the rights? Do they know what their rights are? You can go ahead and list it. And then they have so much time to exercise that first right of refusal. And if they do not exercise the first right of refusal, then you can go ahead and sell the property. So go ahead and list it. Because they might not exercise their right of, they might not go ahead and get that property under contract. Most of the time they don't. So you have to make sure that the regulations are discussed in the docs. So,
let's see. I've got another question from Barb Deggins. The question is the agent liable if they know of pending assessments but doesn't disclose on condo writer?
Do you have a key to share?
No, it's a code to the ground. Jody, can you go on ahead?
Sure. Let me qualify this by saying I don't represent Chadwick Group or any of the market centers or any of the agents in terms of actual legal advice, but I will give you my opinion on this. And my opinion is that if you know a material fact that may affect the value of the property, that you also have a duty to disclose. And that would include a pending assessment. If there's an assessment, and I like to use extreme examples, like when I teach the contract class, because it's so absurd, it seems obvious, but the extreme examples work just as well as the ones that are, kind of close calls. So if there's an assessment on a $200,000 condo, and the assessment is $150,000, I mean, that's clearly going to affect the value of that property. And if you know about that and don't tell the buyer, then I think you probably, may share in some of the liability.
Interesting.
Thank you for that.
Jody. Homeowners Association.
Okay, moving on. To the second writer.
Questions on condo writer? Are we good?
I think we're good on those questions. Thank you.
Awesome.
All right, so the HOA. This is fairly similar to the condo association that we just went over, with some material differences. Basically, the homeowners association is generally used with single-family homes, townhomes. Occasionally, they're used as part of a master association in condominiums. And Rider A is really for condominiums because they're actually kind of different properties. So by Florida statute, let's just start off with the really interesting part on this. Florida statutes require that there's a disclosure summary, and it's in bold and capital. So, they're really trying to get our attention here. Requires that the buyer receive a disclosure summary. Okay, this isn't all of the disclosures. It's not all the condominium documents. This is a disclosure summary, and the disclosures are contained in this rider. So we're meeting the statute by giving the buyer this rider, and the disclosures, go on, and it's, if you're buying a property in this community, you're obligated to be a member of the association. There have been or will be recorded restrictive covenants. So there's a list of 9 things in here that you're trying to make sure that the buyer is aware of. Again, this is a summary because the HOA documents will have more detail than this right here. This is just a summary that Florida statutes say that we have to make sure a buyer understands. Now, this document has to be given to the buyer. There's a big, bold, in fact, in the contract, there are only 2 places in the entire contract that's all capitalized and in bold, and this is one of them. So in the actual contract, they're really trying to get our attention that they need, and the caution is that the buyer needs to read this prior to signing the contract. Okay, in my opinion, it's not a requirement. Okay, and a lot of people have different opinions on this. I'm just giving you my opinion. It's not a requirement that they've read it before. However, the buyer has an opportunity to be able to cancel the contract within 3 days of receipt of this document, or at closing, whichever one's earlier. So to put it a little more simply, if you haven't given this document to the buyer during the transaction, you get to the closing table, the buyer literally can walk into the closing and say, I'm not going to close, and get their deposit back. Right? So you don't want to be that agent. This is a good document to put in the MLS. Yeah, this is a good one to put in the MLS. So when the buyer's agent is, preparing an offer, they go to the little attachments. Here it is. All right. Now the buyer is able to sign it. They have it, and you don't have to worry about that cancellation period. That's statutory, and you cannot waive it. Right? There's nothing that we can put in an addenda that says the buyer waives the right to be able to cancel. It's statutory. You can't waive it. So make sure you're getting this to the buyer's agent. If it's not in the attachments, which it should be in the MLS, then make sure the buyer's agent has it immediately. If you're on the buyer side, make sure you have it and your buyer's aware of it. You don't want to have that person, your buyer, have the right to be able to cancel this contract. And it goes through these statutory disclosures. Now, one big difference between this and the condo rider or the condo association rider is that it's the buyer's responsibility to get these documents. Okay, the buyer is responsible. On the association, the seller is responsible for providing them. On the HOA, rider B, it's the buyer that's responsible for getting the documents. Let's see. If you are working with a buyer, okay, make sure they're getting their documents. There's a contact area down here at the very bottom that will let the buyer know who to contact to be able to get it. This is the association, to be able to get the documents. They're also generally in public records. So the buyer needs to get it, become familiar with it, understand what they're buying, and us as good buyer's agents want to make sure that they are getting the information that they need. They are getting it. We don't want to provide the documents. Again, we'll go back to that boat trailer example. I've actually seen that happen. We want to make sure that the buyer is reaching out and getting the association documents. Okay, any questions on that?
Jody, is there a liability if the buyer's agent gets the documents?
I think there is. I mean, because if we've provided information and the information turns out to be false, then I think we probably would share in the liability. I haven't litigated anything like that, but I would think that, we are misleading the buyer, whether intentionally or unintentionally. We'll go back to the boat trailer example. If it's really important, if this person is a commercial fishing guide and has to be able to keep his boat in his driveway because he leaves at 5 a.m. in the morning to go pick up his clients and buys a home and all of a sudden finds out that the association documents have been amended and they no longer allow overnight parking of trailers. That person just bought a house and can't do their business. They're going to be upset. And I think if we're the ones that misled them, intentionally or unintentionally, to purchase the house, thinking they'll be able to keep their boat in the driveway, then I think we may share in the liability.
Interesting.
Again, this is my opinion based on my real estate knowledge. So anyway, let's move on a little bit. So there's a part B to this section. These are all the disclosures. They're fairly self-explanatory. You know, the developer may amend it. There may be an obligation to pay rent or land use fees for recreational. You may be obligated to pay special assessments to respective municipalities. Also that the condo association may be able to place a lien on your property for non-payment of fees, either your HOA dues or any special assessments that come up. They may be able to lien your property. And if they put a lien on it, there's the chance that they will foreclose the property. And so a buyer has to know that there's a master governing association that is going to control the community, is going to control in some respects what happens on, you know, in the community they live, and may amend those things and may be able to put a lien on the property. So that's why we have this big disclosure. Section B. So when we move down to section B, this talks about the association having the right to approve the buyer, and the buyer must obtain approval within a specified number of days before closing. The addendum defaults to 5 days. This is kind of similar to the condo association. That the buyer must pay all applicable fees unless the association rules provide otherwise. And if the buyer is not approved within the stated time period, the buyer can terminate the contract and get their escrow deposit back. So when you get down here to, let's see, section 2, payment of fees or assessments. So this is up here in section 1, we have a section about what your HOA dues are, okay? And then down here we have payment of fees, assessments, and other association charges, and where the buyer pays for the application, the initial contribution, and membership or other fees by the association, and then their box to be able to fill it in. When you get to section B right here, 2B, if levied, special, or other assessments exist as of the effective date, right? They've been levied, they've been assessed, the seller is aware of them, the homeowners association has made the community aware of them. If they exist as of the effective date, or an assessment is levied after the effective date but prior to closing, and any of those assessments may be paid in installments. Okay, installment is where it's a large amount. You pay a certain amount in the very beginning, and then a month later you pay another amount. Usually these go with really large assessments that people generally can't write a check. Let's say there's a $10,000 assessment to bring in utilities, or you're all on septic and the county's bringing in water and sewer. And so if they can be paid in installments, then the seller shall pay all the installments due before the closing date, and there's an opportunity to check a box here, who's going to pay it after the closing. Is the buyer going to pay after the closing, or is the seller going to pay everything up at closing? And this is very similar to the language about special assessments in the contract. So if it can be paid in installments, then the seller pays up to closing, and depending on which box is checked, and one of these boxes has to be checked, then whether the seller is going to pay whatever's due after closing at the closing table. So if there's $10,000 and it's $2,500 a piece, and there's 4 installments, 2 have been paid, there's still $5,000 remaining. Is the seller at closing going to pay that additional $5,000 even though it's due after the closing? Or is the buyer going to assume whatever installments come after the closing? All right, any questions on that?
So we have question number 1, going back a little bit, is a general question about the documents. Are we providing by emailing or attaching to the MLS? And then I have another one.
I mean, if you attach it to MLS, it's there, so the buyer's agent can have it and make it a part of their offer package. I mean, I love it when, if I'm working on the buy side and I'm looking at a property, getting ready to make an offer, and I click the attachment, and there's everything. There's the seller disclosure, there's the lead-based paint, there's the HOA. Not only does it make it easy for me to make my offer, but I also know I'm dealing with a professional on the other side, someone who handles their business. And, it may not necessarily be true, but it kind of gives me the impression that this is somebody that's, probably going to be a little easier to work with because they're going to the extra step and they're being professional. So put it in the MLS. If it hasn't been provided, email it. Or if you get an offer and you put it in the you put the HOA disclosure in the MLS, and the offer comes and it's just a contract, and that happens sometimes. You know, agents are new to the business, or they're in a rush, or they just forget, and you look and you see that the HOA isn't attached. You know, call the buyer's agent. Say, hey, listen, you know, there's an HOA rider, there's a seller property disclosure. I don't see them included with your offer. Would you mind going and pulling them down there, giving them to your buyer, and send it over, and then I'll submit the entire package to my seller to review.
So Doreen had a follow-up to that question, which was, her point is that we shouldn't provide documents because of liability. We are providing by attachment to MLS and email.
Are you saying that, okay, I may be confused. Are you saying provide the HOA disclosure, this rider, or actually the HOA documents? Is that what she's asking?
I believe she's clarifying the documents themselves.
Okay, so this is on the rider B, the HOA. It's the buyer's responsibility to obtain the documents, and there's a contact information down here that they can reach out to the homeowners association. They're generally a matter of public record. Okay, so it's, in this case, unlike the condo association, it's the buyer's responsibility. So if I'm the listing agent, I'm going to refer the buyer's agent to the contact information and to public records so the buyer can get the documents. Because again, I don't want to be in a position of, you know, the person whose home I'm selling has lived there for 20 years. They pull out a box from their attic and a file with the documents that they got when they bought it, and like, here are the HOA documents. It may have been amended 20 times and the seller just hasn't paid attention. And now I've provided unknowingly, you know, some false information. So if in this one, there's an opportunity to have the buyer do it, have the buyer do it.
So her final to that is, so don't attach the actual document to an MLS or email. She got it. Okay.
We're required by law to give the disclosures, not the documents.
Yeah, we don't ever attach any of our documents for the condo association or the homeowner association to the MLS, because even the condo association, we don't attach those documents to the MLS, because again, we want those to make sure that we get them delivered, and we need to make sure that the date is delivered on those. And then as to what Jody's saying is, you don't even want the agents to be involved in acquiring the documents. Correct, Jody?
That's right. So we don't have to. So I think it's better to have the buyer do it. So if the buyer makes a mistake, they only have themselves to blame, or the association to blame for providing the wrong documents. We're out of it.
Yeah, and that's just on the association, the homeowners association. The
Yes.
condo rider, the seller at the seller's expense needs to make sure that they get all the documents for the condo association.
That's a great point, and then one of the biggest distinctions. So make sure everybody's clear on that. The buyer gets the HOA documents. On the condo, the seller has to provide them at the seller's expense.
Wonderful. Veronica's asking, so if the HOA requires $1,000 to each new homeowner, is that disclosed here, or would that be something that they would discover when they're reviewing the HOA documents?
Sorry, is that you broke up at the last second? So if the HOA requires $1,000
to each new homeowner, right? Is that something to be disclosed here, or is that something that they would discover in the HOA documents?
I think I would definitely disclose it. I mean, my opinion is disclose, because, and I really am a big fan, especially if it's something material, of using email. Because email, you know, you have a time date stamp that you did something. So if there's something that needs to be disclosed, I'm going to let the other agent know, because again, standard O, delivery or notice to the agent or attorney of the other party is the same as delivery to that party. So, you know, if I know that there's $1,000 assessment coming up, I'm going to email the other agent and say, just want to let you know this may be coming down the pipe. There's $1,000 assessment. You know, I've made them aware of it. If that agent doesn't tell their buyer, that's not my responsibility, because I provided some type of notice.
And let's preface it that it's in writing, always in writing. Because when you say tell, we want to make sure that it's always done in writing, because if we verbally say something, it doesn't count.
Right. It's exactly. And when you're writing an email, take a second, think about how is this going to sound in court, okay? And if you're hot or upset or mad and you're banging on the keyboards, take an hour, write it, come back and look at it and think about how is this going to sound in court? Because that's one of the reasons we're paper trailing. And if you have a verbal conversation, you can follow up with the email. Just wanted to confirm our conversation a few moments ago that the buyer is going to waive X, Y, and Z, or that the seller is going to contribute A, B, C. So now you have something in writing. So if it's something material, I'm a big fan of just sending an email, because now I have a time date stamp that this was done contemporaneously with the contract.
Correct. In factual data and not an emotional response. And then I'm always a proponent of making sure I read my emails out loud prior to sending them. I tell my team that as well. Make sure you just briefly just read your emails out loud prior to sending them. Make sure that what you're thinking actually came out on the written. Just best practices. Because I'm, going, and I'm like send. I'm like, oh crap, that just didn't get out the way I wanted to say. And then I regret sending it so quickly. Anyway, keep going. Sorry, thank you.
All right. So, if there aren't any other questions on the HOA,
It looks like there's a lot. No. Okay.
Nope. We're all
then let's
caught up.
move on to writer C.
Okay. Thank you.
All right, picking up speed here.
Seller financing, purchase money mortgage security agreements. The seller. This addendum begins with a dire warning. Warning. Okay, prior to entertaining this financing. Guys, this references the Dodd-Frank on Wall Street Reform and Consumer Protection Act and other relevant federal and state requirements. And it just gets better from there. Woo-woo. The entire first page is a summary of Dodd-Frank and who may enter or may not be exempt from complying with its requirement when a seller extends financing for a buyer to purchase the property. Guys, this is something where seller financing, when somebody says to you that they will do a seller carry, they'll do a purchase money second, they'll carry some financing for the buyer. There's a number of different ways to say this, but this is what they're talking about. They'll loan money to the buyer. There's so many different ways to say this. Red flags go up, and really what you should do is, what I'm going to do is, why don't we get an attorney involved here, to go ahead and help you with this, and we'll write this up. Because if you do go under contract this way, you're going to want to get an attorney involved to write this up, because this is a second mortgage, and this is where your pay grade doesn't involve you anymore. This is way above your pay grade, okay? So you want to make sure that you get an attorney involved to write this up for you, because an attorney is going to write the mortgage for you. Does that make sense? Agents beware, honestly. This is just something. Listing agent contains provisions regarding the type of financing that a seller may or may not consider for the transaction. When you're in the listing presentation, if the seller indicates interest in offer seller financing, advise the seller to see his or her lawyer immediately. Honestly, go and seek attorney's advice. If the buyer's interested in doing something like this, again, they should also seek an attorney's advice as well. That's really the best thing here to do is, because here's the thing is, if the seller is interested in doing this, especially in an environment like this, they're looking at being in second position behind a first. And in an environment like this, being in second position, and somebody fails on their first mortgage, they're going to get 0 cents on the dollar if they short sale. So if your seller is interested in this, don't want to advise them of anything except to say you might want to seek an advice of an attorney. If you're at the listing appointment, you're going to really just want to stop and say, if that's something that you're interested in, you're going to want to advise your seller of that. Does that make sense? My advice is to not do it in an environment like this. It's so topsy-turvy right now. Any questions on this?
Drew has a question. He says, would you partner this writer with a buyer's attorney's review writer?
Interesting question. I'm going to go ahead and give it up to my attorney.
It's not going to hurt. I mean, if the buyer is bringing an attorney in, you know, that really, I mean, the buyer's probably going to let you know, hey, I want my attorney to review this. Anytime you're bringing an attorney in, you're going to get two things. You're going to get a 10-page opinion of why the sky is falling on every single paragraph, and you know, and how many different ways they can try to show how smart they are to screw up the contract. You'll get that, and you know, you'll also get some level of confidence that, you know, whatever it is you've told your buyer, the buyer has sought a professional, and their opinion is what the buyer should be relying on. So, you know, you've kind of lifted some of your liability from anything you may have advised the buyer on in doing this, because you've done what you should do. You've advised them to seek appropriate counsel. Jen's right. I mean, this is above our pay grade. It should be drafted by an attorney. And if the buyer has an attorney on their side, the seller, unless they're really, really, really knowledgeable and don't want to do it, the seller probably should have an attorney. You know, we want to be the source of the information. We're talking about legal documents that we're not trained on, and each party should be represented. And so, you know, I think that if you have a buyer approval, you know, that's going to be the buyer's call, but it's not a bad idea.
I mean, this document refers to a balloon mortgage too. I mean, and Section C, and you know, a balloon mortgage will cause the buyer to balloon in such and such a time. So if that term is 3 years, you know, you're gonna, all of a sudden the entire payment of the mortgage could come due in 3 years. So that's what that references. You know, adjustable rate, you know, you're gonna reference an adjustable rate in Section D, where your rate could be starting out at such and such a term. Say right now where it's, you know, less than 4%, it could go, you know, for something like this, you know, your second mortgage could be 5% or 6%, and then your adjustable rate could go up with prime. Who knows what the prime lending rate will be in so many years. So it could go up to, you know, 7%, 8% as an adjustable rate, and continue to adjust with prime as interest rates rise in what happens in this environment. Who knows? So, you know, this is a very risky time period to be doing a seller financing. So very, very risky. And what index are you going to, you know, attach it to? Is it the LIBOR? Is it the 10-year ARM? Is it, you know, so again, we don't know these things to talk to them about. And that's why it's definitely best practices to go and talk to an attorney.
And think about it, you know, right now, interest rates are so low and lenders are so aggressive or accommodating, you know, to all types of buyers, not all types, but many types of buyers. You know, some of them still have pretty low requirements for their credit score. I mean, it's pretty easy to get financing right now. If somebody can't get financing and you're having to use this, that might be a red flag to the seller. So it's not like a time where, you know, the interest rates are, let's say 10% or 15%, and you have to have a 780 credit score. This is more applicable. Right now, this isn't something that really is going to come into play much, unless it's an extreme situation. And if that's an extreme situation, attorneys.
Yeah. I've heard that jumbo loans are no longer in use, so that could be something why, if you're doing, you know, something where you're doing luxury properties. But again, I think we beat this one.
Okay, next.
Thank you. Next.
All right. So assumption of existing mortgages.
You know, I just want to add something. I think this was used when we had really high interest rates.
Yeah.
Honestly.
And we don't have that now.
You think?
So it's really, you know, not something that's real applicable right now. If things change, this may come more into, into favor. But right now, there's really not a lot of reason to use it. And if somebody needs to use it, you really need to kind of take a good hard look. So, and I mean, one situation might be somebody who's making a ton of money. They have proof of funds, but they had a bankruptcy. That might be a situation where you do this. But again, we want to get professionals involved in something like this. So, assumption of existing mortgages. So this is where the buyer is assuming the seller's existing mortgage. So the seller completes the addendum, provides basic information regarding the mortgage or mortgages that are on the property. And the seller is also required to get a statement from each lender as to like the balance, the method of payment, interest rate, status of the mortgage, et cetera. It's kind of like an estoppel certificate when you're buying an investment property in 6B in the contract. So the seller needs to provide all this, or alternatively, they can authorize the buyer or the closing agent to get the information from the lenders, right? So the buyer basically needs to understand everything about the loan that they're assuming. So the buyer is then responsible, or the buyer agrees to get their application to be able to assume this mortgage, and diligently go about completing it, kind of like we have in Section 8, where you have to use good faith and diligent effort to be able to obtain the mortgage. The buyer is also required to work diligently to submit everything they need to submit to the lender to be able to assume the mortgage. And if there's any cost associated with this, the buyer assumes it up to a certain amount. And there's a blank that, you put the cost to be able to assume this mortgage shall not exceed, X amount of dollars. And I think the default is 1%. Okay. If the buyer does not get approved, okay, or the terms of the assumption are materially different from the terms that are in the contract, or the lender charges more than the amount stated in the addendum, then either party can cancel the contract. Alternatively, one or both parties can increase the amounts and continue with the contract. You can modify it. So the bottom line on this is most conventional mortgages aren't assumable. And again, like we just talked about, it's pretty easy to get financing right now. And the interest rates are really aggressive. Whatever you're assuming probably doesn't have as aggressive an interest rate as what you could get right now if you have decent credit. So we don't see this really in conventional. Where we do see it is sometimes in FHA and VA. All right, it's generally not done in conventional, but FHA and VA are assumable. But just keep in mind that just because the buyer assumes an existing mortgage from the seller, it doesn't mean that the seller is no longer liable for the debt. Okay, the seller stays on the hook for the debt. So if seller A is selling a property and buyer assumes that mortgage and then begins paying on it, seller A is still responsible for the debt until that's paid off, if you allow the buyer to assume the mortgage that you originally got with the house. Okay, the only way that changes if you get something called a novation, and that's basically a new contract stepping into the shoes of an old contract. And I don't know that lenders are really wanting to let people off the hook. They went through the entire process with you. You've been making your payments on it, and it's just safer for them to keep you in the deal. If they're going to let you out as the seller, going to let you out and put all the liability on the buyer, then you're going to have to get something called a novation, right? So also another thing that you need to keep in mind when you're advising buyers and sellers is on a VA loan, okay, if a buyer is also VA, okay, and unless the buyer VA is substituting their rights and eligibility to a VA loan for the sellers, okay, then they're using the seller, unless they do that, then they're using the seller's eligibility. So the seller may not be able to go out and get another loan for another house for VA financing, right? So when you have VA, you have certain eligibilities. If you allow somebody to assume that, unless it's a VA buyer that's substituting their eligibility for yours, you're kind of on the hook on that loan until that loan is paid off. I hope that makes sense.
Because you have the previous loan in order to actually use your VA eligibility again.
Yes. So your eligibility will be attached to that property unless the buyer substitutes their eligibility for yours. And then you can go on and use your VA to buy another property. Excuse me. So let's see, what else do we have on here? If you're a listing agent, you should make sure that your sellers understand that they may not be off the hook on their mortgage. And also, if it's VA, that they may be giving up some of their liability. They have to have a good understanding of this, and make sure they have a conversation with their lender about what they're giving up or what they're not giving up. Buyer's agents, we need to make sure that the buyer consults with the appropriate professionals to make sure they understand the terms of the loan that they're assuming, because most of us aren't lenders and we need to stay in our lane. So they need to make sure that they understand what they're getting, because whatever the seller negotiated back in 1980 when they got their loan, or 1990 or whatever it was, may not really be in the buyer's best interest. And so you need to have a conversation with the buyer about whether they're assuming that or whether it's in their best interest to get their own loan right now, their own financing right now.
All right, we good?
I think we're good.
All right, we don't have too much more time. Oh my God. We need FHA VA.
All right.
All right, we ready? This is good. All right, we want to make sure that everybody knows that FHA and VA and what the designation, the difference is between the two. So FHA is an insured loan. Just want to make sure everybody knows that. That's insured by the government. VA is guaranteed by the government. That's the difference between the two of those. So I don't know if everybody knows that. FHA, the difference is that FHA has a FHA upfront insurance, like private mortgage insurance, and VA does not have that. They have an upfront mortgage insurance or insurance if you are not disabled. If you're disabled, VA is the best loan you could ever get in the world, because there's no upfront VA funding fee at all. There's no upfront VA funding fee if you are a disabled vet. It's the best thing ever. If you end up as, God forbid, you're a disabled veteran, but if you are, then you don't have to pay any upfront VA funding fee. And then it's 100% loan that's guaranteed by the government. FHA, I mean, these are for people who have, a little bit less credit and they don't have as much down payment. So, some of the talk right now is that there's some greater overlays on some of the lenders and that some FHA are going away, but FHA is here to stay. So just know that FHA and VA loans are here to stay because they are insured by the government and guaranteed by the government. And it's their job to loan to those people. So just know that they are here to stay. I just want to preface that before I go into this, okay? So there's rumors out there that they're going away. They're not going away, okay? So just find the lenders that can loan to these people, because it's the government's job to loan to these people. All right, just wanted to make sure that everybody knows that. Education is always key to us. It's probably the most misunderstood addendum, honestly. And you just want to make sure that you're using the correct addendum. When you put this into DocuSign or to .loop, whichever you're doing, you want to make sure that you put in federal or veteran, because when you go to the lower left-hand corner, you want to make sure that it says CR5 as the version. Some people don't put that in and they put FHA and they end up with the CRSP version. And that's not the correct version, because that's, again, when we started out this class, I wanted to make sure that you start out with the correct version of what you're using so it attaches to the correct contract. Now, speaking of the correct contract, this addendum speaks to the standard contract. So, and it speaks to it because it actually references different paragraphs in the addendum to the standard contract. And we're going to go through that. In section 2 of this addendum, inspection and appraisal, you will see that it actually speaks to the standard contract. And I always say this too. So, and this is, again, I'm going to get on a little bit of a soapbox. These people are people who have a little bit less down payment. And because they have a little bit less down payment, they don't have the money to do the repairs to the home. And so they're probably not going to be able to do them after they move in, right? So this is why you should always reach for the standard contract when your standard offer, when you're making your offers with an FHA or VA buyer, because you want to go ahead and use this offer in that section for the general repairs, the WDO, and the permits, because you want to help these people. So you want to help them in helping them to make the most repairs up front and during the contract, so that they don't have to make the repairs while they're living in the home. Does that make sense? Because these folks need your help. So that's why the standard contract is the best thing for these people. It was generally made for these folks. So that's why FHA VA is best used for these people. And then in section 2, this is where it says, you know, in addition to the requirements of paragraph 12 of this contract, sellers shall comply with FHA VA regulations regarding termite inspection, roof inspection, and appraisal repairs, collectively appraisal repairs. The cost to the seller for appraisal repairs shall not exceed, right here, this is your appraisal protection for the contract, which cost is in addition to the costs required to be paid under paragraph 9A. This is in reference to the standard contract, and 12B, C, and D. So right there, it speaks to the standard contract, right there. Unbelievable, doesn't it? So this is where you have it speaking to the standard from this addendum. Now, if you use the as is, it's a dichotomy. So do you understand that? So it like literally doesn't go with the as is. You can use it, but this is where it doesn't actually match it.
So Jen, we get a question often, if I'm using the FHA VA addendum, do I also need an appraisal contingency as a separate document?
You don't. No, because it actually says this, and I'll go through this. In here, it actually states it in here that you have an appraisal. It states where the appraisal goes, and because it said, we'll go through this. So I'll go through it in this section. So let me go through it. You're jumping ahead, sorry. So I just, that's why, everybody understands, I mean, Jody, you get it, why you should use this addendum with the standard, because these people need our help. You know, you can go ahead and help them in the best way possible to make the repairs now. That makes sense, right?
Makes sense.
Okay. However, the addendum is most of all, you know, it's listed as an allowed addendum for the as is, despite the fact that the contractual provisions referenced in the addendum are quite different, but they follow the provisions of the standard. Paragraph 2 addresses the inspections and the appraisals, referencing the paragraph 12 of the contract. Remember, the standard contract, the seller is required to make certain repairs and address issues in 3 categories: the general repairs, the WDO repairs, and the permit issues, just like I just spoke to in paragraph 9A. The addendum provides that in addition to those requirements in paragraph 12, the seller is also required to comply with all applicable FHA and VA regulations requiring termite inspection, roof inspections, and appraisal repairs. Paragraph 3 purports to address FHA financing. You should always go back to your lender too. So, and find out what it costs to, for any cost for the lender charges. So what is your lender? Always make sure that you go back to your lender and say, what is it going to cost for any kind of loan expenses? So paragraph 3A, any fees and prepayments. purchaser shall pay up to all loan expenses except tax service fees at charge. So, you know, up to a maximum of blank. So what does it cost for the tax services, any other fees that it's going to cost? You know, somebody asked me one time, they called me up for a contract question and said, can I change from a conventional loan to an FHA loan in the middle of an effective contract? And I said, first of all, you have to alert all parties. Second of all, you're going from a good loan to a lesser loan, and you have to make sure that fees are going to be disclosed because there's fees that need to be paid. And then there's also an appraisal inspection that needs to be done during the contract. So you have to check with your seller and see if that's going to be acceptable to your seller. And then there's also extra fees that need to be paid. So you have to talk to the lender. What are the fees that are going to need to be paid? So, you know, you have to disclose that too. And then you also have to add an addendum. So these things have to be disclosed, and then fees need to be agreed upon. So here's where you have to talk to your lender and find out what are the fees that need to be paid. And then appraisal repairs need to be agreed upon as well. So here's where you have to talk about, you know, changing, if you change a financing in the middle of a contract also. The appraisal repairs section in there, I covered that. What is it given? I talked about that. Oh, the question about the appraised value in section 3, the first section on the first blank on the appraised value. Here's where it covers your appraised value. Your appraised value is covered right here. So you do not have to do an appraisal contingency on an FHA or VA loan, because your appraised value is, if it's FHA, you check the box here on section 3, and then you put your appraised value right here. Correct, thank you. So you do not have to do an appraisal contingency on here because this is covered. Your contract does not cover for conventional. And Jody and you and I were talking about this. So your contract does not cover for conventional. So you do want to do an appraisal contingency on all of your conventional, at least we do for best practices, especially now in an environment where we don't know if there's going to be an appraisal shortfall on what's going on in our environments. My opinion, we're still in a seller's market on the current environment, but we don't know where it's going to be heading. So we do, on all of our purchase contracts, we do an appraisal contingency for conventional, but on all of your FHA VA, you don't need to do that because your FHA and VA addendum covers your appraisal. So that's where your appraisal value goes in. So questions that we have right now.
You are so thorough that unless there's a qualifying question, I think most people are just absorbing.
Okay. So VA financing. Oh, let's keep on going on FHA. So what if there's appraisal repairs that exceed? So the seller receives notice that there's excess cost in appraisal repairs. They have 3 days after the receipt of notice to give the buyer notice, and then the seller gives notice to pay all of the excess, or the seller gives notice to pay less than the full amount of the excess, or there's a third choice, the seller gives notice to pay none of the excess. If the seller gives notice to pay less than the full amount or none of the full amount, then the buyer may pay the balance of the excess and proceed with the contract, or they can cancel the contract and then the buyer gets their escrow back. Okay. And then paragraph 3C requires that the parties and the broker's agents to certify the contract that everything is true and correct, meaning that there are no side agreements. Paragraph 4 addresses if it's a VA loan. And just like paragraph 3, a type of appraisal contingency, it's a type of appraisal contingency for the buyer. And if the contract purchase price or cost exceeds a reasonable value for the property as established by the Department of Veterans Affairs, then the buyer may terminate the contract and receive the escrow deposit. And alternatively, the buyer may choose to go forward with the transaction. Paragraph 4 addresses the fees and the prepayments. It specifies that the seller shall pay for the WDO. By the way, guys, in the state of Florida, there's 5 states in the country where the WDO can be paid for by the buyer, and Florida is one of them. I know I get this argument a lot, but the seller has to pay for the WDO inspection, because even lenders don't know that. But in the state of Florida, we're one of 5 states in the United States where the buyer can pay for the pest inspection. Questions on that? And then the rest of the VA proceeds and acts exactly like the FHA, where the seller can receive notice if there's a cost, notice to pay all excess, seller gives notice to pay less than the full amount of the excess, seller gives notice to pay none of the excess, and so on, if there's a appraisal shortfall.
Jen,
not appraisal shortfall, but appraisal costs. If there's a greater cost for the appraisal, sorry. Jody, help me out here. Sorry, what am I trying to say? For the repairs for the appraisal.
Drew is asking, where would you find that information referencing that the Florida is one of 5 states, so that you could present proof that is the case?
It's actually in the guidelines for Fannie Mae and Freddie Mac. So you would have to go to your lender and ask for those guidelines. So those are Fannie Mae, Freddie Mac guidelines.
He's very appreciative.
Yeah, and my lender actually provided that to me. So if there's a lender or if there's a buyer's agent that is questioning you, those are Fannie Mae, Freddie Mac guidelines, and he just provided that to me, but I don't have that handy. I apologize. It's a lender, Fannie Mae, Freddie Mac guideline. Any other questions?
No, ma'am.
Okay. We're out of time, Jody.
Good questions, though.
Much time.
Well, I just want to say thank you to both of you. This is probably the most comprehensive hour and a half getting through some of the most common addenda that we experience in these transactions. And I'm so thankful. At first, I was like, great, condo writer. I had no idea that you were going to be able to get through so much in an hour and a half. And the point being here is you have resources in the market centers. There are people here, and it's very evident that you study and you use these, and it's wholeheartedly a reflection of how you're able to negotiate income of service to your client. So thank you both. We've got Kim Van Horn says, thank you, Jen and Jody. Very helpful. Rebecca, thanks so much. So many great nuggets here. Genoa, thank you both. This was incredible. So Barb, thanks, Jen. A lot of people are just really enjoying this. Drew, as always, fancy pants brings the knowledge. Debbie Watts, thank you. Love this. So I know that you have already had the idea of being able to constantly come back and do this consistently throughout, especially as things change and if we navigate through different waters with COVID and whatnot. So again, thank you both for being available here. If someone is wanting to get in contact with you, or if someone is looking for a resource, what should they do?
Call me, text me, 727-410-3598.
Same, 727-455-5175. Or my email is Jody Staples with a Y, jodystaples.kw@gmail. So we're here. That's a great point that Michael made. We're here. You have resources here for you. don't just wing it, ask. We'd rather help you, with a simple question than try to help put out a fire later on.
We really enjoy it just because, as Jody said, he's a dork, I'm a dork. I mean, you can call yourself a dork. Sorry, I didn't mean to call you a dork, but I'm a dork too. I just love this stuff because it helps me to stay on top of it as well, to really, go deeper. And if I don't know something, I'll go find a resource to help you and get better at it too. So,
and
Orns.com.
This is on Facebook Live. This is also being recorded and will be made available to you so that you can go back, look at things. It was really great to have the screen share through most of this. So as you're talking, you're able to look right at the highlighted part. So we're going to make that available to you. It will be in the daily emails that you're receiving, as well as we're working on archiving many of these talks and videos onto a YouTube channel that's directly for the Chadwick group so that you can go back and reference. Thank you both again very much.
So we need to continue. We got to get to appraisal contingency next.
Yes, ma'am. Well, we can definitely put it on the docket for next Friday or sometime very soon. So thank you both.
Thank you.
Bye-bye.
Thanks. Thank you, Jen. That was awesome.
Bye, Jody.